Hello everyone, I am Dr. Rohini Attri, Assistant Professor, Department of Punjab School of Law, Punjabi University, Patiala. The topic of discussion for today is BNSS and victims' rights. Let's start with the introduction, shifting the spotlight to the victim. Imagine being the one who suffers the crime, but then watching the entire justice system revolve around the person who committed it. For decades, victims in India's criminal justice system have lived in the shadows, silenced, sidelined, and forgotten. While the law worked tirelessly to protect the rights of the accused, the voice of the victim was barely a whisper in the courtroom. But now, the silence is breaking. The Bharatiya Nagarik Suraksha Sanhita 2023 or the BNSS marks the beginning of a new era. An era where justice is no longer a one-sided equation and where the victim finally steps into the light. It is not just a change in legislation, it is a transformative movement for victim empowerment. A shift from silence to voice, from invisibility to recognition, from procedural exclusion to participatory justice. In this lecture, we will explore how the BNSS 2023 reshapes the criminal justice landscape by placing the victim at the heart of the process, and not merely as a passive informant or a witness, but as a central stakeholder with the clear rights, recognition, and remedies. Let's start with the legal definition of victim under the BNSS 2023. A foundational aspect of any victim-centric legal framework is the clarity and inclusivity of its definition of a victim. The BNSS 2023 under Section 2, Subsection 1, Clause X defines a victim as a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir. This seemingly concise definition carries with it significant legal and humanitarian implications. First and foremost, the BNSS recognizes that victimhood is not limited merely to physical harm. It extends to any form of loss or injury. This includes not only bodily harm but also psychological trauma, emotional suffering, financial loss, and social harm depending on the nature of the offense. By using the phrase loss or injury caused by the act or omission, the law accounts for both active criminal conduct and failures to act where a legal duty exists. Secondly, the inclusion of guardians and legal heirs make a crucial evolution in the victim's legal recognition. This is particularly relevant in cases involving minors, persons with disabilities, or deceased victims. For example, if a child is abused, the parent or legal guardian can rightfully exercise legal rights as a victim. Similarly, in the tragic event of a murder, the legal heir of the immediate family member of the deceased, who may be the most deeply affected party, is brought within the ambit of victim rights. Such an inclusive definition not only broadens access to justice but also reflects a more compassionate and comprehensive understanding of the impact of crime. Victimhood, after all, is not always a solitary experience. It ripples outward, affecting families and communities. This broadened scope ensures that the procedural and participatory rights introduced under the BNSS are not denied to those who are indirectly but deeply impacted by the offense. Let's move on to the understanding victims' rights in the Indian legal context. Before we dive into the victim-centric reforms brought in by the BNSS, it's essential to understand the traditional role of the victims in the Indian criminal justice system. Under the Code of Criminal Procedure 1973, the victim was largely a passive participant, a mere informant who could lodge an FIR, act as a witness, and hope for justice from the sidelines. The process was fundamentally built around two primary players, the state and the accused. The victim, though the most directly affected by the crime, was often left to navigate the emotional, psychological, and financial aftermath with minimal legal support or voice. This glaring imbalance led many scholars of victimology and criminology to describe the victim as the forgotten party in the criminal justice system. While the accused enjoyed constitutional safeguards, procedural fairness, and even rehabilitative measures post-conviction, the victim often remained on the margins with unanswered questions, unhealed trauma, and an overwhelming sense of abandonment. Even after the conviction, the legal system continues to protect the human rights of the offender, ensuring proper prison conditions, medical treatment, legal aid, and access to appeals. These protections are vital in any rule of law society. However, they raise an equally important question: what about the victim's right to healing, to closure, to dignity? This is where the discipline of victimology plays a crucial role. Victimology, a branch of criminology, scientifically studies the relationship between the offender and the injured party, analyzing not only the nature and the extent of the harm, but also the reasons why certain people or places are targeted. It also focuses on the suffering inflicted economically, physically, and psychologically on the victim. In India, this evolving awareness was echoed by the Honorable Supreme Court in the case of Ratiram and others versus State of Madhya Pradesh. The court observed criminal jurisprudence with the passage of time has laid emphasis on victimology, which fundamentally is a perception of a trial from the viewpoint of the criminal as well as the victim. Both are viewed in the social context. The view of the victim is given due regard and respect in certain countries. In respect of certain offences in our existing criminal jurisprudence, the testimony of the victim is given paramount importance. Sometimes it is perceived that it is the duty of the court to see that the victim's right is protected. This judicial acknowledgement marked a paradigm shift, recognizing the victim not merely as a witness but as a stakeholder in justice. Over the years, slow but significant steps were taken to reflect this shift in law. One of the earliest and most important milestones was the Justice Malimath Committee Report 2003. The committee famously observed that justice to the victim is virtually forgotten in the criminal justice system. It recommended a more participatory role for the victim, including the right to be heard at various stages of the trial, to receive compensation, and to be treated with dignity and sensitivity. This was followed by Criminal Procedure Amendment Act 2008, which marked a turning point by introducing Section 24, Clause 8, allowing the victim to engage an advocate of their choice to assist the prosecution, and Section 357A, mandating the establishment of victim compensation schemes in every state and union territory. Provisions encouraging victim impact statements and promoting sensitive treatment of victims during the investigation and trial. However, even these positive steps were often fragmented, unevenly implemented, or discretionary. The victim was still not a central figure in the criminal process, only occasionally consulted or compensated. This is where the Bharatiya Nagarik Suraksha Sanhita 2023 takes a significant leap forward. It does not merely acknowledge the rights of the victim but institutionalizes them. Let's discuss the role of Malimat Committee in strengthening victims' rights. The Malimat Committee, constituted by the Government of India in 2000 to recommend reforms in the criminal justice system, played a pivotal role in shifting the focus from merely punishing offenders to also recognizing and empowering victims of crime. The committee strongly emphasized a victim-centric justice model and made several key recommendations to ensure victims are treated as significant stakeholders in the criminal process. Some of its notable victim-oriented suggestions include the right of the victim or their legal representative in case of death to be impleaded as a party in serious criminal cases, punishable with 7 years imprisonment or more. Free legal representation for victims unable to afford counsel. The right to actively participate in proceedings by producing evidence, questioning witnesses, seeking updates on investigations, and approaching the court for further directions. The right to file a protest petition against withdrawal of prosecution, bail orders, or inadequate sentencing. The right to appeal against acquittals or insufficient sentences, provision of medical, psychiatric aid, and interim victim compensation. Mandating victim compensation as a state obligation in serious crimes. Regulating the Victim Compensation Fund under the Legal Services Authorities Act 1987. Most of these victim-centric recommendations have found reflection in the Bharatiya Nagarik Suraksha Sanhita 2023, thereby institutionalizing robust protections and participatory rights for victims within the reformed criminal justice system. Let's move further with comprehensive rights of victims under the BNSS 2023. The Bharatiya Nagarik Suraksha Sanhita 2023 represents a landmark shift in the India's criminal justice approach by embedding victims' rights into the very core of the procedural law. Moving beyond tokenism, it introduces structured safeguards that promote the victim's voice, dignity, and participation at every stage of the criminal process. Let us discuss the key victim-centric provisions under BNSS. Number 1. Right to be heard and informed under BNSS 2023. A transformative feature of the BNSS is its focus on keeping victims informed and involved throughout the criminal process. Section 193, subsection 3 mandates investigating officers to regularly update victims on investigation progress in all cognizable cases, bridging the information gap that often isolates victims. Section 223, subsection 1 empowers victims to obtain free copies of police reports and related documents, ensuring transparency and victim empowerment. The BNSS also addresses case closure by requiring mandatory notice to victims or informants before filing a closure or final report, reinforcing victims' rights to be informed and respond. Section 360 further advances victims' rights by allowing victims to be heard before the state withdraws criminal cases, countering previous unilateral, often politically influenced decisions. This is crucial where withdrawals may threaten justice or victim safety. This provision gained prominence in the Rajkumar abduction case, where the Supreme Court halted the state's attempt to withdraw charges against Virappan's accomplices after a victim's family challenged it, underscoring the need to protect victims' interest and public trust. By institutionalizing victims' rights to contest case withdrawals, the BNSS curbs executive discretion and transforms victims from silent spectators into active participants in justice. Number 2. Right to participate and assist the prosecution. Section 339 of BNSS empowers the court to allow an advocate engaged by the victim to conduct the prosecution, particularly in serious or sensitive cases. These provisions ensure that victims are no longer passive observers but active participants in the pursuit of justice, contributing meaningfully to the trial process. Number 3. Right to file complaint and seek registration of FIR. Under the BNSS 2023, victims retain and strengthen their fundamental right to report a cognizable offence. Section 173 of BNSS, which corresponds to Section 154 of CRPC, mandates that the officer in charge of a police station must register an FIR when information discloses a cognizable offence. The use of the word shall create a legal obligation, not a discretionary power. Importantly, Section 175 of the BNSS mirrors the remedy under Section 156 subsection 3 of CRPC. If a police officer refuses to register an FIR, the victim may escalate the matter to the Superintendent of Police. If the grievance remains unresolved, the victim may directly approach the magistrate for appropriate directions. Further, victims may also file a direct complaint before the magistrate under Section 200 CRPC, still applicable under the new framework, offering an alternative to police level registration. Two progressive additions in the BNSS are worth noting. Number 1. Zero FIR under Section 173. Victims can now lodge an FIR at any police station regardless of jurisdiction, a major relief in urgent cases such as sexual assault or abduction. Number 2. EFIR under Section 173 subsection 4 enables victims to lodge complaints electronically, ensuring accessibility and convenience. Especially in sexual offences such as complaints must be recorded by a woman police officer. These provisions address long-standing barriers to reporting crime, including police apathy, jurisdictional hurdles, and logistical challenges. The Supreme Court's decision in Lalita Kumari v. State of UP reaffirmed that registration of FIR is mandatory when a cognizable offence is disclosed, further anchoring the victim's right. Additionally, Section 183 of the BNSS empowers victims to request the recording of their statement by a magistrate. Such statements carry evidentiary weight as they are recorded under judicial supervision following due procedure. Next is right to appeal. Traditionally, the right to appeal was primarily available to the accused against conviction or harsher sentences. However, recognizing the need to empower victims, the Criminal Law Amendment Act of 2008 introduced Section 372 in the CRPC, allowing victims to appeal against acquittal or inadequate sentencing. This was a key recommendation of the Malimat Committee on Criminal Law Reform. Building on this, the BNSS 2023 further strengthens victims' right under Section 413 by explicitly permitting victims to appeal against orders of acquittal, inadequate sentences, or insufficient compensation. This means that if a victim is dissatisfied with the court's decision, whether related to sentencing or compensation, they now have a statutory right to challenge it in an appellate court. This provision marks a significant step in restoring victims' faith in the justice system by ensuring they are active stakeholders with a clear legal avenue to seek fair outcomes, rather than having to approach high courts through special petitions. Next is right to compensation. The criminal justice system seeks not only to punish offenders but also to provide restitution, rehabilitation, and restoration to the victims, the 3 R's, to restore them to their pre-harm status, which is also known as status quo ante. Under Section 396 of the BNSS, state governments must formulate victim compensation schemes with the central government covering medical costs, rehabilitation, loss of earnings, and funeral expenses. When courts recommend compensation, district or state legal services authorities determine the amount. If inadequate or if the accused is acquitted or discharged, courts may recommend additional compensation. Victims or dependents can apply directly if the offender is unknown or no trial occurs. Authorities must decide within 2 months and may provide free medical aid based on police or magistrate requests. Unlike the earlier CRPC Section 357, BNSS delegates compensation primarily to legal services authorities, ensuring more consistent, timely support. Judicial rulings have reinforced victims' right to compensation under Article 21. In Rudal Shah v. State of Bihar, 1983, the Supreme Court awarded compensation for the wrongful imprisonment, while in Neelabati Behra v. State of Odisha, 1993, mandated state compensation for custodial deaths. Courts have also stressed compensation in mass disasters and communal violence, as in Union Carbide v. Union of India, popularly known as Bhopal gas tragedy, and State of Gujarat v. High Court of Gujarat, 2002, emphasizing state accountability beyond prosecution. In Bikramjeet Singh v. State of Punjab, 2013, the court held the state constitutionally obligated under Article 21 and 39A to compensate victims even if offenders remain unconvicted. The Nirbhaya case, 2013, spotlighted compensation inadequacies for sexual violence victims, leading to stronger laws. In Ravinder Kaur v. Union of India, 2014, the judiciary emphasized victim-centric adequate compensation for rape, trafficking, and murder. The Ministry of Home Affairs Victim Compensation Scheme, integrated into BNSS, complements these mandates by providing immediate financial relief to violent victim crimes, enabling faster justice. Together, these reforms and rulings have strengthened victim compensation, reinforcing the state's duty to punish offenders and support victim justice and rehabilitation. Let's get on to treatment of victims. Section 397 of the BNSS mandates that both government and private hospitals provide free medical treatment to victims of specified offences under BNSS and child victims under POCSO Act 2012, while promptly informing the police. This addresses delays caused by the hospitals refusing treatment due to medico-legal formalities. The Supreme Court in Parmanand Katara v. Union of India affirmed that the right to medical aid is fundamental under Article 21, prioritize human life over procedural delays. Further, Section 184 of BNSS requires registered medical practitioners to submit rape victim medical reports within 7 days to expedite justice and prevent document fabrication. Victim identity disclosure is prohibited to protect privacy, and Section 366 mandates in-camera trials for rape and POCSO cases to reduce mental trauma. These provisions enhance victim protection and speedy justice. Regarding legal aid, the Supreme Court in M.H. Hoskot v. State of Maharashtra held free legal aid for the poor accused is a constitutional right under Article 21. BNSS Section 341 provides free legal aid to accused persons in criminal and civil cases. However, the statute does not address free legal aid for indigent victims dissatisfied with the prosecution outcomes, creating a barrier for the victims pursuing appeals or protest petitions. It is recommended that Parliament amend Section 341 to include free legal aid for such victims. This amendment is crucial in complex cases requiring higher court intervention, as exemplified by the Madhumita Shukla murder case, where Supreme Court transfer and oversight led to the conviction, underscoring the need for accessible legal resource for victims. Next is protection of rights of victims of crime through plea bargaining. Plea bargaining was introduced in India following the 2003 Malimat Committee report to expedite trials and reduce case backlogs. Under BNSS 2023, Section 290 outlines plea bargaining and Section 291 sets guidelines for mutually satisfactory case disposal. While it benefits the accused by allowing reduced sentences up to 1/4, it also empowers victims by involving them in the process. They can consent or object during hearings and may receive compensation as part of the deal, ensuring their rights and quicker relief. The scope is limited to offences punishable with less than 7 years imprisonment, excluding serious crimes against women and children to prevent misuse. India restricts plea bargaining to sentence bargaining only, preserving charge integrity. Overall, it promotes victim-centric justice by balancing accountability, victim participation, and timely resolution. Next is power of the Supreme Court to transfer criminal cases across states. The power of the Supreme Court to transfer criminal cases from one state to another is a critical provision aimed to ensuring impartiality and upholding the integrity of the justice system. Under Section 446 of the BNSS 2023, the Supreme Court may transfer a case on the application of either of the Attorney General of the India or the victim of the crime, if it is satisfied that such a transfer is necessary for the ends of justice. This provision is particularly significant in cases where there is a legitimate apprehension that the accused may influence the investigation or trial due to their political or social standing. A landmark example of this power being exercised is seen in the case of Madhumita Shukla murder case. State through CBI versus Amar Mani Tripathi. The deceased sister Nidhi Shukla filed an application before the Supreme Court requesting the case to be transferred from Uttar Pradesh to Uttarakhand due to the political influence of the accused, a sitting MLA. Initially, the police had filed a closure report clearing the accused, but after intervention of the CBI and consideration of the post-mortem and DNA reports, the case was reopened. The Supreme Court, recognizing the possibility of undue influence, transferred the matter to Uttarakhand, where the trial court convicted the accused and his wife. Though the Uttarakhand High Court later reversed the conviction, the case remains a crucial example of judicial intervention to uphold the fair trial rights. Another notable case is the Best Bakery case, arising from the 2002 Gujarat riots. Zahira Sheikh, an eyewitness, sought justice after her family's bakery was attacked and several family members were killed. The trial in Gujarat resulted in the acquittal of all accused due to alleged witness intimidation and poor investigation. Upon the intervention of the National Human Rights Commission and widespread public concern, the Supreme Court transferred the case to Maharashtra, where a fair trial was conducted, leading to a more just outcome. Let's discuss the challenges and the way forward. Despite the BNSS 2023 establishing a solid framework for protecting victims' rights, several challenges hinders its effective implementation. A significant issue is the widespread lack of awareness amongst victims regarding their legal rights and available protections. Additionally, the existing legal aid system is often overwhelmed, limiting its capacity to provide adequate representation to the victims. Many states also struggle with insufficient victim compensation funds, further restricting timely and fair relief. Social stigma and cultural pressure particularly in rural and patriarchal communities, continue to discourage victims from seeking justice. To address these challenges, it is crucial to establish dedicated victim support units across all districts to provide accessible assistance and guidance. Adequate funding and robust implementation of state compensation schemes must be ensured to meet victims' needs effectively. Legal literacy programs aimed at raising awareness about victims' rights should be widely promoted to empower individuals. Furthermore, expanding and legally reinforcing witness protection mechanisms will help safeguard victims and witnesses, fostering a more supportive environment for justice to prevail. Now the conclusion towards a victim-centric judicial system. The Bharatiya Nagarik Suraksha Sanhita 2023 ushers in a transformative approach by placing victims at the heart of the criminal justice process, ensuring their rights and dignity are upheld throughout. This shift acknowledges that true justice extends beyond punishment of the offender. It requires meaningful recognition and support for those harmed. However, realizing this vision demands collective commitment. Law enforcement, judiciary, legal professionals and society must embrace this change with sensitivity and resolve, actively working to make the protections guaranteed under the BNSS a tangible reality for every victim. As Justice Krishna Iyer insightfully remarked, the criminal justice system must correct its historic neglect of victims and restore balance. The BNSS provides the framework. It is now up to us to ensure that victims become active participants in the justice journey, not mere bystanders. I hope you had a great learning experience. Thank you and have a nice day.